Hello, how are you doing? Welcome to Lawyers Infohub. Hello, hope you're doing well. It's a pleasure to always create content on this platform. So today we're looking at pleadings. We're looking at the types of pleadings. We're looking at the aims and objectives of pleadings. We're looking at why you should draft your pleadings well. If you're joining us for the first time, this is Lawyers Infohub and you're welcome. We encourage you to subscribe to the channel. Drop your questions if you have any, because we will attend to it. Lawyers Info Hub is a platform where we teach law in the most simplified way. Is where we try to demystify the big legal concepts in the most understandable way for your success, for my success, for the success of law students across Nigeria and Africa. So we'll look at what pleadings are. What are pleadings? Pleadings are formal allegations by parties to a lawsuit, you know, of their respective claims and defense. Now, someone has instituted an action. The pleadings for a claimant who is instituting an action, part of his originating process is what we call the statement of claim. This is where the claimant is going to tell the stories of why he has come to court. So pleadings, it's a generic word for processes filed by the respective parties stating their claims and defense. Now, we have various types of pleadings which we're going to state. I've used that of a claimant as an example. So there are formal allegations that by parties to a lawsuit stating their respective claims and defenses. Now, for the types of pleadings, we have the statement of claim. No, statement of claim is that process a claimant files. A claimant is the person who has instituted an action, stating his story, stating why he's in court. Now we have the statement of defense. Statement of defense is that process that the defendant, the person who has been sued, files to say, well, this is my own side of the story. This is what I'm stating in refuting what the claimant has said. This is how it is. So statement of defense is now where the defendant will state his own side of the story, countering what the claimant has said or what he feels is the real state of affairs. Now we have what we call the reply to the statement of defense. When the claimant has filed a statement of claim, the defendant has filed a statement of defense, then the claimant has the right to file a reply to the statement of defense to say, well, what the defendant has said is not true, or it is true to this extent, or this is where he makes clarifications of whatever of denials or whatever admissions that the defendant has made. Now we have what is called a counterclaim, where the defendant is saying, maybe I need to sue or I need to claim differently from what the claimant is claiming. Claimant is, for example, is claiming this particular land, and the claimant is saying, no, I'm not just claiming this particular land, I'm also claiming the river behind it, and I'm also want to claim against some other persons. Now, the claimant, rather than file another suit, can counterclaim. In this instance, when the defendant counterclaims, he becomes a claimant in his counterclaim. Why the claimant becomes a defendant. Rather than filing two separate suits on the same issue, a defendant can counterclaim, wherein he's claiming different things, different from what the claimant has claimed in his own originating suit. So when there is a counterclaim, there is a swap in the nomenclature of parties. The defendant becomes the counterclaimant, while the claimant becomes the defendant to the counterclaim. Now, in such situation, when there is a counterclaim, the defendant who has become the counterclaimant has a right to also, when he puts in his counterclaim, the claimant who becomes the defendant can file a defense to the counterclaim. Yes, I know there's also can be a reply to the defense to a counterclaim. So these are pleadings. I said that we have statement of claim, we have statement of defense, we have reply to statement of what defense. We also have a counterclaim as a pleading. We have defense to counterclaim, which is more like a statement of defense. We have reply to defense to counterclaim, which is more like a reply. Now, we have what we call statement of facts. Statement of facts is provided in the rules of the National Industrial Court. In the National Industrial Court, we don't have what we call statement of claim. What we have is statement of fact. It has a semblance of a statement of claim, wherein the party who is the claimant, states his or her story, upon which the defendant will also file his defense to the claim. Now, why do we have pleadings? Why do we have pleadings? Pleadings, it gives an opportunity for parties to state their claims, to state their grievances, to state their reliefs. It helps a party tell his or her story. It helps issues to be defined. When you look at the pleadings, you now know what is exactly the problem. It helps issues to be defined, so that it also prevents one party from springing up surprises. Now, in the era of front loading is a concept where, when you're filing your originating processes, you front load the documents you are using to back your claims. Now, with the help of pleadings and front loading too, the other party will not be taken by surprise. You will not be in the dark as to what this other party is claiming and what they are, the documents or the evidence they are using to back up their claims. A pleading helps to give notice to the upper party of the case which the pleader intends to put forward. When you see a claimant of claim, you already know what the idea of the grievances of the claimant. You already know what the claimant is claiming. He helps you. He puts the defendant on the notice to know these are the grievances of the claimant against you. Now, a pleading also helps to fix the issues for trial accurately. When you look at the statement of claim and the statement of defense, for example, you already have an idea of what are the issues to be looked at during trial. It helps you to look at, okay, what are the fundamental things that this case is built on. It helps you to fix issues for trial. What are the main issues we are going to face during trial? Are we looking at an issue of defamation? Are we looking at an issue of recovery of debt? Are we looking at an issue of land issues? Are we looking at an issue of fundamental right? Or are we looking at issues of matrimonial issues, custody? It helps you, it fixes the issues for trial accurately. It also helps the other party to know the evidence to call to controvert claims, or to build on this case. When you see a plea, for example, the statement of claim of a claimant, the defendant really knows where the claimant is going, and okay, what are the things I'm going to do to counter or to controvert the claims of the claimant. Now, you must understand that the pleading must contain facts in issue. Many a times when you look at pleadings of many people, they don't really, there is a technique in drafting a pleading. When your pleading is not strong, when your storyline is shaking, when it is not put in a chronological order, it can be confusing. You remember that even a judge who is in an arbiter, or who is sitting on a matter, also looks at pleadings. When your storyline starts from the end rather than starting from the beginning, it kind of distorts the thoughts or the reasoning pattern of a judge. When you read, he does not even understand what you're saying. So whoever drives a pleading must do it well. It is like the foundation. And when the foundation of a house is faulty, there's a possibility that the house will collapse. It might not collapse instantly, but it might collapse later. It might collapse later. So it's not very important. It's very important that a pleading is built on a solid rock. The storylines must flow. What happened from the beginning? Don't start the story from the end. I want to end in the beginning. No, start it from the beginning, step by step. Don't jump issues. That is why when a client comes to you and you have taken the story of the of the client, you go through it, you read it, you assimilate it, you ask questions, you fill in the gaps, so that your pleading will stand the test of time. You know what? When you peradventure, the matter moves to the appellate court, you can't change your pleadings. It is your pleading that everything will rest on. So when your pleading is faulty, there is a problem. So that's why I always encourage people. You see, as a good lawyer, as even a law student who intends to be a good lawyer, you must master the act of drafting the pleadings. Very important. If you miss it wrong, there are some people, when they draft the pleading for you, you will begin to see as it was, even though You have not been in the matter. Once you read the pleadings, you know what the matter is all about. Even when you're sleeping, you can be able to recite what the storyline is. So for someone who is also drafting a statement of defense, you must know how to do your admissions. You have to know how to do your you want to you know your denials. You must know there are rules. You have to do specific denials and all of that. You must know how to do them, how to deny your the claims, or the how to controvert, when to join issues. These are taught in the law school, but sometimes in the practical, or when it comes to the practical, you see people begin to mix it up. So these things are very, very important. Now you understand that parties are bound by their pleadings. If parties are bound by their pleadings, that means a pleading must be done well. It's not just something you are doing when you're feeling tired, or when you're sleeping. After you have finished doing your pleadings, you can even give it to a colleague to say, "Help me look at this." That is the foundation. I keep saying it. When the foundation is strong, there's likelihood that the building will stand the test of time. Now, your pleadings also contains your reliefs. What are you seeking as a party who have sued someone? What are your reliefs? Now, for a party who has now filed a counterclaim, also, what are your reliefs? Are your reliefs something that can, sometimes a pleading can be well done, but the reliefs, when you look at the relief, say, wow, this person is not going to get anything. You've seen cases where you say, the reliefs are poorly couched. So there are ways to couch a reliefs. What are you seeking? Declaratory reliefs? Are you seeking an injunction? What orders are you seeking for? Are they just monetary orders? How best do you seek it? How do you draft it? There are ways to draft what please reliefs in a pleading. So you must learn it, read other people's own, learn. When you have done yours, give it to another person with a third eye for review. Now, just like I stated, your pleading must not be evasive. It's not neither here or there. There's nothing. You're not denying. You're not admitting. It's just in between. It has to be. It must be somewhere. So your pleading must not be evasive. It must be cogent and pungent. The words of your pleading must be what clear English. It must be. You don't need to speak too much grammar to make it, ambiguous. Because if your pleading is ambiguous, the judge that's going to read it, how is he going to understand? Let it be in plain English. Use the right tenses and the right words. You're pleading your document. Plead them well. Plead them well. Plead them well. Plead them well. Another thing to point out, this is an extra knowledge on this. When you have, like, we usually do the statement of claim, the witness statement of oath. Also, when you do a reply to a statement of defense, it's good to back it up with a witness statement and oath. You could be a further witness statement on the oath, which is the backing up to your reply. It's very important. Many people just do a reply to a statement of defense without adding the witness statement on oath to back up their reply. Do not use derogatory words on pleadings. It's not a place for you to start insulting the other party. Let your words express yourself, convey what you want to say without being insultive. Don't use derogatory words in your pleadings. It's not advisable. It's not the right thing to do. Your storyline must flow. Just like I stated, it must flow. Don't start the ending of the story. Start from the beginning to the end. Don't just cut things in the middle, thinking, yes, the person is supposed to understand. No, let it flow. Let someone read your pleading and say, wow, I understand where this person is going. I understand the defense of this person. I understand the claims of this person. Let it flow. Let it not be distorted. Let it not be distorted. Yes. So if you're not in a good frame of mind, don't draft the pleading. You must be in a good state of mind, understand what the case is all about, and know where you're going to. It helps you draft a good pleading. So, friends, pleadings are part and parcel of court processes, are part and parcel of lawsuits, they are part and parcel of cases. So, if you don't know how to draft pleading, please go back to the drawing board, ask, learn, look at the ones other people have done. Lawyers work with precedent. Look at what others have done. Look at how they couch their prayers. Look at how they couch their reliefs. If it's issue of special damages, look at how they set it out. And you learn. You must know how to do your admissions. If there's a set off, all those, these were part of the civil procedure classes in the law school. So even when you're out of law school, you should be able to place your hands on them and understand and appreciate what you were thought. So, friends, I just hope you've learned something. If you have a question to ask or you have a comment, please leave it in the comment section. We're open to even we're even open to criticisms, but let it be in a very peaceful manner. Drop your questions, your comments, and it will respond to them if it needs response. We appreciate you who is just joining for the first time. Our returning subscribers, we thank you. You have always been there supporting us. We say, may God bless you. Do take care of yourself and know that you can be better than you are. You can be better than even you were. You can be better than the person you think, is the best. So it's about keep improving yourself, be resilient, and keep pushing. And you know what? The sky can be your stepping stone. Do take care.